Hello, and welcome to our third desk side chat of film production reboot post COVID-19, discussing the cutting edge issues of how COVID-19 affects you, the independent filmmaker. I'm David Albert Pierce, managing partner of Pierce Law Group. This presentation is brought to you by Slamdance Film Festival and MovieMaker Magazine. Slamdance Film Festival is currently open to accept submissions for independent films. Despite everything being in rather uncertain and ever-shifting state right now, Slamdance remains committed to supporting and showcasing independent filmmakers, no matter what form that will take this year. We can't wait to watch your films, and Slamdance knows how important it is to make sure the world sees the most daring, original, and thought-provoking works that come Slamdance's way. Slamdance Film Festival. Save money by submitting early prior to July 13th for your independent film and that festival. Also want to thank MovieMaker Magazine. If you're a filmmaker trying to finish a project now, especially if you're in post or looking for publicity help, our friends at MovieMaker have a program called MovieMaker Production Services, where they'll double your budget through partnerships with their sponsors. If you have a starting budget of at least $10,000, they can double it for you. You just want to email tim@moviemaker.com, or you can direct message them at the @ MovieMaker Mag. It's MovieMaker Magazine and their filmmaker support group program. Well, let's get right into it right now. America is reopening for business, and we need to learn how to reopen safely. Just a little background information about me for those who are speed readers. I'm not going to stick too long on this. Pierce Law Group does both entertainment, litigation, and transactional matters. We do everything from soup to nuts, from film financing to distribution deals, all of your intellectual property, cast and crew agreements, licenses, location releases, other clearance releases, and general crisis management for whenever you're on the set, and all of those unusual things that arise during a production that you never thought were going to happen, but they just do. With that said, as to who I am and why I'm speaking to you today, let's get right into it about the restart of productions. Here in California, they've given the green light to restart. In many other areas around the country and around the world, they have equally given the green light and permission to start. With that said, there are a lot of requirements that filmmakers have never previously had to deal with. You have to deal with COVID-19. SAG will not let you begin productions, won't even let you make an offer to actors until you present a COVID-19 plan to them that meets their approval. So those of you who are familiar with Station 12, the requirement right before production to make sure that all of your actors are eligible to work per union rules. You can almost think of it as an early Station 12 requirement back when the offers are going out. You need SAG's green light to even make those offers. They want to see that you are COVID-19 compliant. Also, if you are dealing with any sophisticated financier, they too are going to require you to be COVID-19 compliant. I was just working yesterday with a a small studio that's getting ready to gear up production in July. They're dealing with their bank, their lender, and they had to get out, first thing today, their COVID policy for that lender to look over, so they feel satisfied and comfortable giving their money over to a production that is not going to wind up having to shut down because all of its actors and crew members are in need of ventilators, God forbid. Perhaps the biggest thing, aside from the fact that you do have the federal Osha law, which has a general rule that has always been in place that requires employers to have a general duty to provide a safe workplace for all employees. This clause requires employers to keep their workplaces free of serious recognized harms, and that goes for both not only injuries but illnesses that can occur in the workplace. So that's the general all-encompassing federal law. Many states, such as California, have an equivalent state law. It's called Cal-OSHA, and that general rule parrots what the federal rule says. You have an obligation to provide a safe and healthy workplace for all of your employees. Now, aside from these federal and state rules to provide a safe and healthy workplace for recognized hazards, and COVID-19 is now a recognized hazard, there are issues separate and apart from the law. Primarily, your financing, as I said earlier. Not only do banks want to see your COVID-19 plan, but completion bond companies want to see your COVID-19 plan. And more importantly, completion bond companies are absolutely requiring that you have insurance that covers COVID-19 issues. Now, the problem with that is, as of last week, and I know things change very quickly, and I was gonna make a call to some of my assorted insurance brokers and agents and people that have the pulse on these type of things early this morning, but I did not get a chance to get through to them. But as of last week, in my conversations with all of them, there is no national or even international insurance group that is presently writing COVID-19 coverage. We are keeping track of this. If something changed over the last 4 or 5 business days, I'm sure someone can chime in. I have the ability to read my chat boxes here now, but somebody will likely do that. We will let you know. We'll keep you abreast of the developments in the insurance world. But it's a real catch-22. And let me see where we, because just because the state and other jurisdictions have said you can commence production, it doesn't mean you'll be able to. Because it don't mean a thing if you ain't got that COVID-19 insurance. And the catch-22 is as problematic as the COVID-19, which means the catch-22 being you're required to have a completion bond if you're working with any sophisticated financer, certainly if it's a lender, certainly the more sophisticated repeat equity players are always going to require a completion bond. And if you're working with those type of people, you're gonna have to have a completion bond to get the money. You're gonna have to have insurance coverage in order to get the completion bond. That's your catch-22, and the catch-22 can be as problematic as the COVID-19. As I said, the insurance companies have yet to start issuing COVID-19 policies as of when I last checked around last Wednesday or Thursday. So maybe some new developments have arisen over the last 4 or 5 days. I would think that some insurance carrier somewhere is willing to price this risk. It may be extremely expensive insurance, but with so much of COVID, it is, we're dealing with a pandemic. That is going to be a premium that you need to factor in to each and every one of your budgets. So whatever if you did a budget before COVID-19, go back and factor in all of the additional costs that are going to be a result of the COVID-19 surcharge. And what do I mean by the COVID-19 surcharge? You're going to have extra employees for the purposes of cleaning the set and overseeing the proper protocols, which we're going to discuss further in on this webinar. You might also not be able to get as many of your day-a-days completed as your original shoot schedule was. Shooting schedules may be delayed because it'll take longer with makeup, with wardrobe, because you can't have everybody together. Your meals period perhaps may be longer. You're going to have less people on the set. You won't be able to do so much as much multitasking because you're going to want to limit the amount of people that are around. So there are certainly a lot of additional expenses that will arise with the COVID-19 issues that you are going to need to address. And insurance is just one additional cost. What those premiums are going to look like, stay tuned. We are, checking every week with, the absolute top brokers in the industry. And as of last week, I was getting all of the same answers. Check back with us. We're not finding any companies that are willing to issue coverage quite yet. And that makes sense. You can understand why that would be. They're already reeling with all of the unexpected claims that COVID-19 is presenting to those insurance carriers. All the forced business interruption cases that are coming in, and all of these other claims for policies that never anticipated a pandemic and failed to fully and expressly carve out the COVID-19 pandemic from coverage. And the way insurance law works is if there is any ambiguity, any doubt, all of that goes in favor of the insured and against the insurance company. So if it's arguably covered, it's covered. So anyone that was in the middle of production and got shut down by the government orders, if you had an insurance policy, you're probably in good shape. They may be making a fuss and kicking and screaming, but you're probably in good shape. Here's a question. This is great. Keep pinging these questions as you can, and if you could shut that door as well, that would be wonderful. The question is, PPI, want to know if you're talking about workers' comp or general liability insurance. We are talking about general liability insurance. However, I'm glad you brought up the issue of workers' comp because if your employees are injured or contract an illness while at work or on duty, that is covered by workers' compensation. And first, let me pause and say that is a good thing. Workers' compensation is a production company's best friend. And the reason for that is because the workers' compensation bargain is this: in exchange for there being no fault, meaning the question is simply, was the employee injured at work or on duty, or was he not? And if the question is it was injured at work, then you don't have any discussion of negligence. You don't have any discussion of intentional harm. You could have done everything absolutely right. He could have done everything absolutely wrong. But if there was an injury in the workplace or on duty, it's covered by workers' comp. But Dave, you said workers' comp is our best friend. That doesn't sound like a good thing. If I went to court, I could argue my case that I'm not on the line for this. Well, workers' comp is your best friend, because in exchange for you not having the ability to argue anything other than was it or was it not occurring while at work and on duty, you get a definitive answer as to how much that employee gets. You eliminate the uncertainty of what a jury may do in terms of issuing an award for punitive damages and determining what the emotional distress is and what 12 people in a jury box think this injury is worth, versus what actuaries determine the injury to be worth. And when you're on workers' comp, everything is a schedule, everything is a table, everything is extremely micromanaged in terms of how much is paid out. It goes by exactly how old the person is, what type of job they have, what type of injury they have. Everything is based on ratings, and there is a number that is kicked out on the basis of a formula. And when you are dealing with catastrophic loss or something like a COVID-19 situation, I would much rather have that formula applied where the numbers are punched in and you know exactly what that amount is, rather than have 12 members of a jury scratching their head and just flying by the seat of their pants in determining how much money the employee is entitled to receive. So workers' compensation is great protective measure for you. And I imagine that workers' comp premiums may go up. I don't believe presently that is as big an issue as the general liability insurance issues are. I would think that general liability insurers should recognize that at least the employee injury stuff should be covered entirely by workers' comp. So what is the general liability insurers' concern here? Why are they afraid to price this product? Well, it's that business interruption insurance. It's the idea of, what happens if the production has to completely shut down. It's while workers' comp covers the cost of the illness and injury, the cost of the medical treatment, the business interruption insurance is going to cover all of the contractual losses for money that you're still going to need to pay, regardless of where the production is. It's also going to pay for all of the consequential losses, your inability to finish the film. Where does general liability insurance and business interruption end and a completion bond begin? Well, that's the topic of another desk side chat. And, that's something that's parceled out between the completion bond company and the insurance carriers. Again, that gets back to our original question of, why the completion bond companies will only issue a completion bond if you have insurance coverage for COVID-19. The completion bond company, their benefit of the bargain, what you get in exchange for you giving, say, 2% of the budget of the overall budget of your film, you are giving that to the completion bond company. They, in essence, are giving you a type of insurance that says, come hell or high water, if you go over budget on this movie, they will come in and provide the finishing funds to make sure that your film is in the can and ready for delivery to the distributor. But like any insurance type provider, everybody likes to take that bet. Everybody likes to take that premium. Nobody likes to pay that out. And they want to take every step possible to minimize the risk of a payout. And currently, completion bonds are saying, what we need to minimize our threats of a payout, we need insurance coverage. And I suppose you could have a carve out with the completion bond company that says you do not have to pay if the reason for cost overruns and an inability to deliver the film is because of COVID-19. If your investors and financiers are comfortable with that, then maybe that's the way to go about it. But if you're dealing with a traditional lender, and I think if you're dealing with a serious repeat player in the world of entertainment financing, I don't foresee them willing to play ball and make that exception. But at some point, as Peter Graham from 120DB, a longtime film lender and sophisticated film financier for years and years, said, they're in the business of, financing films. That's their business. That's how they make money. And they want to be in business. They want to do deals. They don't want to be sitting on the sidelines. So maybe there'll be some innovative solution to all of this, or maybe an insurance carrier is going to be able to finally price the risk. And I'm sure that they have their own actuaries that are running charts and looking at all the latest data and trying to come up with a way to issue a policy. So that goes back to the first part of this slide, which is if you don't mean if it doesn't mean a thing if you ain't got that COVID-19 insurance. And then I have under that says indies may likely proceed, but any production requiring a completion bond may be in trouble. Here's where you, the independent filmmaker, actually have a leg up on studios, because I know I work with a lot of you, many of you, most of you, in the under 5 million range are doing so without a completion bond. Even some of you above the 5 million range, when you're not dealing with sophisticated lenders or sophisticated financiers, are moving forward without a completion bond. So you do not have the hurdles and impediments that the majors and mini majors are facing in this issue. All in all, it's enough to want to make you swallow a bottle of Lysol, but we don't want you to be doing that. So assuming you do you have your financing, and the state and jurisdiction in which you're in has given the green light to do production, let's take a look at how that production is going to evolve and what you're going to do. So we talked about the general safety rule under the federal law. is you have a duty to provide a safe workplace, and then there's a bunch of other safe standards that need to be imposed. Everyone is also supposed to have a safety manual. And again, filmmaking is generally classified as a hazardous activity. You know, people get injured, people die on movie sets, and the government is aware of it, and they want to see, you know, even on an independent film, a proper safety manual that addresses known hazards. And now that COVID-19 is a known hazard, not only are you going to have, separate and apart from your regular safety manual, we're going to have a COVID-19 safety manual. And what are some of the things we want to have in that? Well, you want to make sure that you're appointing a COVID-19 safety director. Now, all of you should know that the crew member who is the single responsibility for supervising and ensuring safety on the set, while safety is everybody's responsibility, the one guy who's really holds responsibility for that is the first AD. And people always ask, that's so odd. Why is the first AD in charge of overseeing all safety issues? Well, actually, whoever first came up with this was really brilliant, because they understand that what is the first AD's primary job duty? It's to make sure that the production stays on time and on budget. And the first AD does that by making sure that they get all the shots that are required to be shot for each day of shooting. And the first AD is the guy with the bullhorn that's saying, come on, people, hurry up, we're losing the sun, we need to set this, we got to get this scene, let's go, okay, check the gate, we're off with this one, let's get set up for the next, right? He's the timekeeper. So it makes sense. What if you didn't have the first AD primarily responsible for the safety on the set, and it's his fault if as to, hey, what happened here? Why did this injury arise? If that wasn't his responsibility, and his or her only responsibility was to make sure you get your days, you're going to have a guy speeding. And speed leads to potential safety hazards and injuries. So let's make the same guy who wants to speed be the same guy who is policing safety, so that you don't go any faster than what is the proper rate of travel, so that no injuries occur in the workplace. It was really, really brilliant. Many of you might not have ever thought about the correlation between why the first AD is the safety guy and is also the guy who makes sure that things are running on time. That was a masterful delegation of duties. So with the COVID-19, it's my belief, and I've heard from some people that some first ADs are kicking up a fuss and saying, we don't want to be responsible for this. Well, you're ultimately in charge of safety. We're going to have a COVID-19 safety director that is just focused on that, but you, the first AD, need to be responsible for all safety issues, and that includes COVID-19. And in order to have a seamless set, in order to have a seamless policy, a coherent safety plan, you need to have the first AD regularly talking to your COVID-19 safety director. The two have to be in cahoots and understand what's going on. And the first AD has to understand that because of these new COVID-19 protocols, he's gonna have to slow down the pace a little bit to account for the implementation of those protocols. We want to make sure that you're going to have to ensure social distancing, and we're going to go into details about how you do that. Having essentially one of the ways, aside from following all of the basic rules that we hear in the public service announcements, stay 6 feet away, wear your mask, have protected face shields, wear gloves, those type of things. Wash your hands frequently. Those are all part of the social distancing rules. We also want to maintain a strict closed set. Filmmaking is not going to be as much fun. You know, the only people that should be on location and on a set should be those that absolutely need to be there. And when should they appear to set? Only when they absolutely need to be. So schedule their call times, schedule them proper. Make sure you're structuring it so that not everybody's showing up at the same time. If someone doesn't need to be there until a certain time, don't require them or even permit them to be there any earlier than they absolutely need to be. And when their work is completed, they should not stick around. I know usually people want to, let's stick around and, oh, they're going to film that scene. That should be funny. Oh, they're going to do that stunt. I want to stick around and watch that. This was all a part of regular filmmaking, what's made filmmaking fun. That was what's fun to be in a crew. It's fun just to, you know, have a BS session around the craft service table and talk to people. Filmmakers are incredibly interesting people, be it the actors, the crew. I love hanging out at film sets. In a COVID-19 world, that just can't happen. And you can't be, if you're a producer and you want to bring your investors on, you know, on the set, which a lot of them want to do, I just don't know if that really amounts to you know, an essential person. And you really need to limit the people to only those people that are going to be essential. As I mentioned, you want to provide the sanitizers, your wipes, your mask, your gloves, your face shields. Consider having work groups sequestered with each other. What does that mean? All of the people that need to interact with one another within, while still maintaining social distancing, you want to corral them all together. So the cast, makeup artist, hair people, they can all be, can stay together in one area. If particularly if you're traveling people to a location, they can all be in the same section of the hotel, and to the extent they are permitted to socialize with anyone, they should socialize with the folks that are designated within their zone. Your camera people and grips are going to be segregated together. Have your set decorators and prop designers, in a separate group. And if they can come on and do their stuff, hours before the camera crew and grip gets there, then that's what should be done. There are a lot of innovative ways of dealing with the segregation and sequestering of employees. And it's not a one size fits all situation. You're going to have different rules if you're using just all local hires who are sleeping at their house at night versus people that you are traveling. As you may have read, Tyler Perry at his studios has created essentially, one big camp that everyone is going to stay right in this perimeter area, and you're never going to leave. The food's going to be brought into you. Whatever socializing you're permitted is going to be more computer oriented, and you're going to stay, and you're not going to go out to bars at night when you're off duty, or go to restaurants and that type of thing. It does present some interesting wage hour issues, but I think all in all, people should be voluntarily willing to comply for the good of the production for everyone, to not put themselves at risk because if they put themselves at risk, well, they're going to wind up being quarantined for 14 days and going to be losing a great opportunity to be working on the film. And more importantly, they're going to be putting their coworkers at risk. So there are a lot of innovative ways to deal with the social distancing, to deal with sequestering of people. Generally, extras are not treated particularly well on any size budget of a film. They're usually all corralled together in a big extra pen. We're going to have to make sure that social distancing, at very least 6 feet apart. And if you could spread them out even more, and give, they all start to get their own little separate structures, similar to what a day player would get, or in a, of some sort of private dressing room area. You'll need to factor in these type of things. So think about it. We have already gone forward and developed a COVID-19 compliant policy for one of our clients that will soon be engaging in production. They happen to be particularly lucky because prior to the COVID-19 outbreak, they, thinking in advance, not thinking of advance of the COVID-19, but just being well-prepared line producers, executives, they had their insurance already lined up. They didn't wait until, 4 weeks before production or 2 weeks before production to contact an insurance broker. They did it at day one. So even though they're planning on starting in the summer, and maybe they were going to start a little bit earlier, but they postponed, they already had their insurance coverage in place. Similarly, any film that was disrupted that restarts production, I believe, you have to check your insurance policies, but if they had the coverage for the film, that's going to stick there, so they too would have their insurance coverage in place. So that particular studio was able to solidify all of its financing and completion bond because they have the insurance, and that insurance carrier has to just be wringing their hands because they weren't able to issue a COVID-19 carve out because the policy was bought before COVID-19. So we've drafted their COVID-19 plan. We're still putting some finishing touches on it. We're really proud of the way it looks. And if any of you are moving into production, we can do the same for you. And again, I think COVID-19, just like any other contract, it's not something cookie cutter. Don't just get it offline. Don't just say, well, this is what our other production used or our friend used. I've curtailed this particular one to comply with Texas state law. Every state has a slightly different standard. Texas has a standard for what temperature is too high and someone has to go home, which might be lower than another state's temperature standard. So please, this should go across the board with any contracts and forms you use. I know, every line producer has a little toolkit that has, lawyer agreements that they got from 10 years ago from some production they worked with. Every time you do that, it's like taking someone else's medical prescription. Yeah, 80% of the time, it may work fine for you and be just what's needed. But 20% of the time, you might have a terrible allergic reaction. And it could be the absolute worst contract because it wasn't custom tailored for your needs. It was custom tailored for someone else's needs. Worst case, best case scenario, you're giving away more than you needed to give in a particular situation by using those form contracts. So when you reach out to a lawyer, know that you shouldn't be paying the lawyer for their forms. You're paying them for all the knowledge of understanding what are in those forms and how those forms should be properly tweaked for your particular production. And note that each safety plan, each COVID-19 plan should really focus particularly on how we're going to keep these people separated, how the logistics are going to work. They really should be thoughtfully engaged in and done in a way that is specific for your project. Common areas, high traffic areas, they need to have cleaning enhancements. There should be a deep clean every day, and throughout the day, cleaning should be visibly occurring and frequently occurring, focusing on what's known as high touch points. Each morning on the set, prudent practice is you should always have a 10-minute safety meeting. That the first day everyone gets their the call sheets handed out. People are told what the unique features of filmmaking are going to be that day. Today we're going to have pyrotechnics. Today there's going to be a stunt. It's going to be really hot. We're filming in the desert. Make sure you stay hydrated. There should always be a 10-minute safety meeting at the start of every day of production, led by the first AD, that talks about the unique hazards that might be faced that day. And if there are no unique hazards, just brush up on good common safety. The idea is to have safety always in the crew's mind. Now, implement into that 10-minute safety meeting a COVID-19 meeting. So it's always in people's mind, reminding them of what's occurring. You also want to make sure that at the start of each workday, I would recommend at the middle of each workday and at the end of each workday, the safety COVID director and his team is going around and taking thermometer measurements of everybody. And if they have a temperature of over 100, let them sit down for 5 minutes, cool off, take it again. If it's still a high temperature, you need to start going into quarantine protocols. You need to have them tested right away. The production that I just worked on, that's getting ready for production in July, their protocol is everybody gets tested when they start work, and they have a 24-hour testing turnaround. And you can't start work until those test results come in. And then every 3 days, people will be retested. And if they have a fever, they get retested then, and they need to sit out until that test comes back clean. It's a pain in the ass. I get it. And producers, I'll tell you something else. Not only does that crew member have to sit out, but under the COVID leave laws that were passed by Congress, every employee is entitled to up to 2 weeks of paid sick leave. That's broken down into 80 hours. So you can take it in incremental time, just like family medical leave could be taken in incremental time. And they get paid for that time, for the 2 week period, if they are forced to be on the sidelines because their temperature was high or because they were quarantined. What happens if someone tests positive for COVID-19? You have to do contact tracking. You have to figure out everyone that they've worked with in their department, and that whole department needs to get tested and may need to be quarantined for a time period consistent with what the medical directors say at that time. You want to do a deep cleaning of the sets and locations every morning and night. And then, as I said, a lot of routine cleaning. If it's possible to dress a set 48 hours in advance and leave it untouched, that is recommended. If you can't do 48 hours, the more advanced planning that you can do, the better. And again, have the set dressers in there when the cameramen and grips aren't even around. Let's take a look at some questions. We'll stop here. We'll come back to some others. Cost of testing kits covered by local government, or is the production responsibility? If testing is not available for free in your jurisdiction, here in California, it's available for free. It is all the cost of medical exams are borne by the employer. That is the case in California. I would say you'd have to check on a jurisdiction by jurisdiction basis if your state laws or international laws have that same requirement that medical testing, just like any other item that the employee might need to perform their services, has to be provided at the cost of the employer. So masks, gloves, the protective eye gear, all needs to be provided by the employer at the employer's expense. Very good question. What if production shoots under the umbrella of a company that already has insurance? If you are clearly designated as an additional insured, and I would not just go on the opinion of whoever the parent company is, or a friend of a friend, I would talk to the insurance broker directly and make sure 100% that coverage exists. And I would want to see a certificate of insurance that says, yes, this production company is definitively a covered production under this larger policy. Because if you don't have that in writing and confirmed, I can tell you, you may see a problem with the insurance carrier when a claim comes in and them saying, hey, you're not the name on our policy. So get it confirmed by your insurance broker, get it in writing, ask to see a separate certificate of insurance with you added as an additional insured. Does size of a production matter? Size always matters. SAG, short, project, re-COVID compliance. Yes, actually, it will be easier for a small production to comply, but everyone has to comply. Remember, the OSHA safety rules are, you have a duty to provide a workplace that is safe and healthy, free from all known potential hazards. So doesn't matter if you have 5 employees or 500 employees. I would think it will be far easier to implement the protocols if you have 5 rather than 500. Again, another good question. Let's get back to some of the basic protocols of what need to be in your policy. Have a security guard police the entrances and make sure that the 6-foot rule is always being followed. You don't want to have any any bypassers if you're filming in public or anything like that that crosses into the realm of the production company's area. Craft services and meals all need to be boxed and eaten remotely, not in groups. I know that's half the fun of making a film is bullshitting around the craft service table. Here's something to think about. Crowd scenes should be replaced with CGI rather than having 100 people in a crowd. COVID compliant behavior argument versus COVID liability waiver. What's the difference? You cannot have an employee sign a waiver that says, if I suffer an illness or injury, I will not sue you. Right? We just talked about that. It's workers' comp exclusivity. Workers' comp exists in all 50 states, and they all are, however different they may be, they all share the same characteristic and basic function. That is, if an employee is injured or suffers an illness while at work or on duty, the employer pays, and there's no question of fault. So any attempt to have an employee sign a waiver that says, I promise if I suffer COVID-19, I will not sue you, is going to be rendered null and void, and contrary to what the law requires. You can, COVID-19 to that extent is no different than any other injury or illness in the workplace. It's possible you could have a waiver for people that do not fall within the category of employee. Many of you are saying, aha, I'm going to have everybody be independent contractors. This is not the time to play fast and loose with the legal distinction between employees and independent contractors. And California and a number of other states have really closed in hard on who's an independent contractor and who's an employee. Even if they're paid through a loan out, which can be a topic for another desk side chat, where I'll tell you why a lot of people think the sky is falling concerning loan outs in light of the California AB 5 law, which seeks to render anyone that performs services that are essential to the making of a film, and that's just about everybody, maybe not your craft services, maybe not your lawyers and accountants. Well, there's special exceptions for them. Yeah, but essentially anyone that serves the essential function of production needs to be an employee and not an independent contractor. And that is for workers' comp concerns. It's also for certain wage hour concerns. But a topic that can be discussed at a future chat is, it's not so much that they're an independent contractor and not employee, as it is really that there's a joint employment relationship when you use the loan out properly. The loan out is the primary employer, the production company is the special employer. You, the person that owns the loan out, that is the employee, is being lent out by the primary employer to the special employer. So there's two employers involved, and the only thing that's being treated as independent contractor-like is the payment of wages, where taxes can arguably not be taken out at the special employer level, provided they are duly taken out at the primary employer level, the loan out company level, which is what the employee owns. I digress. That's a little more sophisticated discussion than today. Just know you don't want to start playing fast and loose with employees and independent contractors, and there can be no waiver for employees. If you're going to a Trump rally, you're not an employee of Trump. You want to waive your rights to go in a crowded convention hall with 100,000 people, and everyone screaming and yelling, wave away to your heart's content. We'll let the courts decide how valid those waivers are. They probably are. They probably are. It's more like going to a sporting event. When you enter Dodger Stadium, there's a lot of waivers on the back of a Dodgers ticket. But employees cannot waive the right under workers' comp laws. They've already, via workers' comp, waived the rights to sue you in civil court. In exchange, you automatically pay and take care of them via the workers' comp setting. And then you can sometimes go into the civil court if it was really egregious, if you violated some OSHA laws and did it with reckless disregard. There are ways in which an employer can find themselves in civil court rather than have the protection of the workers' comp. That's for really egregious stuff. And you could see how some really egregious stuff might happen here with the COVID world. Couple other points. Let's see. We talked about the crowd scenes. Here's something interesting. ADA and HIPAA prohibit you from revealing the names of an employee that has COVID-19 unless the employee grants consent. Here's how this should work. It's got to be a practicality. If someone tests positive for COVID-19, you go to them and say, look, we have to tell everybody in your group that they need to quarantine. Do we have your permission to let them know it was you? And encourage them to do the right thing, because they would want to know if the shoe was on the other foot. It's going to be upsetting to crew to know that somebody has it. And in reality, people are probably going to figure out who it was. So, but if someone is really a jerk and says, no, I don't want my name revealed, well, then you just say, hey, someone you work with has it, and you still take the same protocol without naming them. When you take the person's temperature 3 times a day, that isn't really considered medical information. So I'm told it doesn't have to be treated as with the same level and the same requirements that a COVID-19 finding of a positive result would have. You still want to maintain it confidential. There's no reason for others to really know. I would maintain it in a separate log, and I would keep it in with the same level of confidentiality that you would any other personnel record or document that you would consider to be confidential, and I'd keep it probably separate from the personnel file itself. But I'm told that just recording temperatures is certainly permissible, and I'm not too worried about people sharing that information. Again, if they have a high temperature, we can discuss that offline if that's a major issue for you about how to deal with the temperature controls. So we talked about this, why these policies are needed. And if you don't have the right policy in place, you're not going to have insurance. If you don't have insurance, you're not going to get a completion bond. And if you're not going to get a completion bond, you're not going to get financing. And if you don't have financing, the cameras aren't going to roll. There have been different approaches to how do we develop COVID policies. SAG-AFTRA has developed a bunch of safety tips, and they've kind of have been honing in on the different types of SAG members. So they are crafting and are continuing to craft safety tips for COVID-19 that apply to performers versus broadcasters versus recording artists, stunt performers, voiceover artists, special rules for children on the set. Again, I always tell people, children are an expensive luxury for an independent film. Find an 18-year-old that looks 14 rather than an 18-year-old. Even under a non-pandemic world, you have a whole separate rule of labor laws to follow. Our firm specializes in child labor issues for the entertainment industry. And there are a lot of major studios that will employ us just to oversee that all of the child labor laws are properly complied with in regards to the child actors and getting the appropriate child actor ratifications and such to legally employ a minor. If you're an independent filmmaker working on a shoestring budget, children are a luxury and they are expensive. and you don't want to cut corners with safety, particularly when children are involved, because that is not going to go over well in any court of law, and you won't be relegated to workers' comp for that. Lionsgate was one of the first to come out of the chute to develop their COVID-19 protocols and procedures. And that is available online. You can see what Lionsgate has done. And there was a Hollywood white paper that is becoming the real, I think that's going to be the thing that everybody follows. It's kind of like, you know, when Sony had the Betamax and versus the VHS, and VHS became the standard and nobody wanted beta. Well, the white paper is like is going to be the VHS of COVID-19 protocols. Who contributed to the white paper? All these folks, all these big name people, a lot of production companies, a lot of unions, all working together with a lot of medical specialists determining what's right. It focuses on infection control, physical distancing, protecting and supporting cast and crew, and training and education. There are, you know, like I said, every union, every production is going to have specific issues. So don't just take a cookie cutter COVID-19 policy. Make it unique to your policy. Are you filming locally? Are you filming on location? What are the unique circumstances that need to be evaluated from a COVID-19 lens? You know, are you involving animals? Do you have minors? You know, these are all things that if it relates to your film, you want to have properly in there. Special considerations for wardrobe care and makeup, for location scouting, for extras, you know, film permitting. Make sure that your COVID-19 protocols are ADA compliant. You know, is there anything in your COVID protocols that presents a problem for those with disabilities? This morning, I heard on Good Morning America about a guy who refused to wear a mask on an American Airlines plane because he claims he had a disability that prevented him from wearing a mask. And, you know, they tossed the guy off the plane, but then they had to let him back on because they're not allowed to ask. All they're supposed to ask is, do you have a disability? And they're not supposed to inquire the disability. Now, an employer has a little bit more freedom to structure an ADA exam with an employee who is working, because they do have the right to ensure the safety of not only that disabled employee, but those who work around them. But you do want to see, are there some type of disability concerns, and what type of accommodations need to be made for that? Before you go into this, before you even do, or as part of your creation of your COVID-19 protocols and policies, create checklists. Checklists are a wonderful thing. You know, brilliant minds can come up with what needs to be done, put it in a checklist form, and less brilliant minds can implement it. You know, you want to make sure that the policy is covering everything. How are you going to communicate your policy with employees and the public? Is there going to be posting? Everybody should get one. The question about a COVID-19 liability waiver versus a compliance agreement, well, that is where you want to use the compliance agreement. You want to have an employee receive the 6-7 page COVID-19 protocols, employee acknowledgement at the end. I have read and shall comply with all of the terms and protocols set forth in this COVID-19 policy. And I understand if I fail to do so, you know, I may be terminated without, you know, any further discipline. Get them to sign it. The same way you have them sign a no harassment policy and a commitment to adhere to that. 1, it's educating them. 2, it's giving them advance notice. Don't follow the rules and you're out. difference between a compliance agreement and an acknowledgement of the policy versus a liability waiver. And I know that most people call what I just talked about a waiver. It's really not a legal waiver. You could, if you're just having a guest on the set and the guest is essential for some reason and is not an employee, sign a waiver that says, if you come in here, you're not get, and you get COVID, you're not going to blame us. But always check on the specific facts and circumstances of what the law and the jurisdiction is and what the relationship is to that party. But it's generally not going to fly with employees. Other things, your cooling and air conditioning systems, you want to make sure that those are checked and properly cleaned. We've talked about a lot of these other issues. Disinfect the props. Minors should be accompanied by up to 2 adults, and you got to keep extra close eye on them. You should always be keeping a close eye on minors anyways, because filmmaking is a dangerous activity. And let's face it, some of the crew, if they weren't working on a film crew, would be essentially circus roustabouts and drifters. And you want to keep an eye on some of those folks if there's a 13-year-old running around the set. Think about things like pens and having them being disposable, or once somebody has a pen, they keep it. A lot of little things, but they make sense, and you don't have to reinvent the wheel. A lawyer is going to have these protocols already ready, the checklist to give you. You can also, go online and find a lot of these sources. A lot of government sites provide that information. Communicate with the employee, a copy of the protocol with a signed acknowledgement, and have some signage posted all about as constant reminders. And of course, have your 10-minute tool talk. So real quickly, Los Angeles has allowed films and television to reopen, but you're going to need to have the protocols in place. An interesting thing that is unique to California, I don't know, maybe other states have adopted this, but there's an executive order that says if an employee contracts COVID-19, it is presumed they contracted it in the workplace. Remember, I said workers' comp applies to any illness or injury that they contract while at work or on duty. Your argument would be, well, how do I know you didn't get it at home? How do I know you didn't get it at that bar you went to with 1,000 people, or the protest rally that you went to on your day off? In California, there is a presumption, a rebuttable presumption, that you got it at work. That means if you know they went to a rally or to a crowded bar, and particularly if there was news that that crowded bar or rally led to COVID-19 spread, and you have no other spread in your company, then you may win that rebuttable presumption. But it starts off with the presumption that they got it in the workplace. That's set to expire July 6th. I'm sure that will be extended probably through the end of the year. Let's see, you want to ensure compliance with your jurisdiction. Florida, Nevada, Texas, South Dakota, Montana, and Illinois have all adopted some different rules that relate to filming, as has Missouri, Hawaii, and North Carolina. All of these states are open for business for filming, as are Oakland, Oregon, and Colorado. So whatever jurisdiction, and Georgia, New York, and Washington. Whatever jurisdiction you're filming in, take the time to figure out if there's something unique in what that particular law may require. Same thing goes for international if you're filming overseas. Austria, Poland, Spain, New Zealand, UK, Czech Republic, Iceland, Portugal, Canada, France, Russia, and Czech Republic. I guess we said Czech Republic twice. I like Czech Republic. they all have different policies and protocols. They're pretty much saying the exact same thing I've spent the last 45 minutes talking about. So you do want to take a once over of what that jurisdiction looks like, because you want to make sure you're in compliant. And the one thing you don't want to be is non-compliant in a foreign country, because some of them might have very different laws for non-compliance than the slap on the wrist that America might give you. What are some helpful resources? I'm a helpful resource. We can walk you through it step by step. We custom tailor production documents. We draft safety manuals and COVID-19 compliance programs. We will help you train supervisors. We will help in crisis management for COVID-19 or any other situation. We've been doing this for an awful long time. And I'm always reminded of the Dustin Hoffman's portrayal of Bob Evans in Wag the Dog, where every time someone comes to him with a problem, he just throws his hands up and says, "That's not a problem. You want to know what a problem is? I'll tell you about a real problem." And he goes on to talk about some, amazing, difficult catastrophe that happened on any of his, hundreds of productions that he's seen over, his 50-year career. We feel a little bit that way. We've worked on hundreds of productions, and it's very, very rare that we ever raise an eyebrow and say, well, wow, that's a new one. The facts may be a little different, the situation may be a little different, but the overall problems, the legal issues that are raised when a crisis arises, we've pretty much, confronted everything and anything, and we have experience with how to both hopefully prevent those things and how to nip them in the bud and how to solve them when they arise. Part of our production counsel services is your ability to call and say, you're not going to believe this, but this just happened, help. And more often than not, we're pretty darn good at offering that help. We can also advise you on force majeure issues and insurance issues. And every crew member, a deal memo, if you're using cast and crew memos from 6 months ago that come out of your UPM's toolkit, that needs to be dusted off for at least no other reason than addressing COVID-19 and force majeure. And in some situations, you may want COVID-19 to be a force majeure. When you want to hold somebody else to their obligation, you want the opportunity to say force majeure and hit the tolling button and say, don't you go anywhere, you still owe an obligation to me. In other situations where you're the one that's giving the obligation, you may not want to hit the tolling button and say, you still owe an obligation to me. You may want to say, let's call it quits. Let's recognize this contract's purpose was frustrated, and let's return everybody to their original position. Either, we owe no further obligation moving forward, or we make it like we never contracted before, ever. These are highly fact specific. They involve a cautious analysis of what you're trying to achieve and what you want to accomplish. And it can, when you're doing standard crew deal memos that people really have no say in the negotiation with, you want to make sure it's worded just the way you want it to be worded. And different agreements can be worded in different ways. And if you're dealing with more sophisticated contracts where there is negotiation, think about how this fits into the negotiation process. And we can advise you on insurance issues and completion bond matters. We got a whole Rolodex filled with, experts and brokers and analysts, and they can help you achieve what you want to achieve. Although following one of our last desk side chat, a very significant production company that makes big independent productions and regularly does so, they contacted us because they had heard, through this rumor mill based on, these desktop chats, that Pierce Law Group can figure out a way to get insurance on this, that they have the answer. I said, well, as of today, the answer is there's no carrier that's writing these policies. We can help you draft things that sidestep insurance, maybe create things that look similar to insurance. But if the idea is you need a recognized, well-funded insurance carrier to issue a policy so you can get your completion bond, so you can get your financing, you know, as of today, our magic wand is not working, and we can't create an insurance carrier to provide coverage if there are no insurance carriers to provide coverage. I would very much like to work with them and understand, you know, what their economic analysis is and their cost benefit of risk versus premium is, to try and encourage them that they still should write these policies, and why these COVID-19 protocols will work. But insurance carriers are a pretty conservative bunch, and they'd rather wait and see how things play out rather than just issue a policy and say, well, this will be fun, let's see what happens. Especially when they have so many previously unanticipated, unexpected claims that they never thought at the start of 2020 they would be having to pay out on. And again, there's our phone number, there's our website, directly at piercellp.com. There's a link that will take you to our lovely client director, and the appropriate Pierce Law Group attorney will respond to you. And we have some folks that really sharp with financing, others are really sharp with labor and employment issues. I'm kind of the jack of all trades that I'm extremely proficient in all areas that the firm practice, which I guess is the reason why my name is on the door. Also, you can see a number of my articles that I have published over the years for MovieMaker Magazine, and we'll be doing another one very shortly for MovieMaker on this very issue. Those can be found at moviemaker.com, and aside from me writing, MovieMaker has a whole slew of columnists and guest columnists and reporters that are following these stories. And if you're friends with Peter Baxter, or you've got the right contact at Slamdance, the folks over there are pretty darn knowledgeable as well, and they have some amazing filmmakers resources. This website that was kind of partially a brainchild in conjunction with them is but one of their many resources, and their commitment to independent filmmakers and to helping your guys out in a real esprit de corps spirit that is independent film. Some relevant articles I have published, and I haven't published, that I have found and aggregated. I have available those that are interested in them, along with specific links to every state, federal, and international website source that deals with COVID-19 and safety issues. We have them all chronicled. We can make them available to you. They're available to our clients at no cost. If you're not a client, we can have a consultation with you and make some of that stuff available to you. But if you're not a client, why aren't you? You should come on in. We're pretty good at helping you work through whatever problems you can. But if you don't use Pierce Law Group, please, one thing that you should walk away from this thing is use someone. Don't fly by the seat of your pants. Recognize that there are experts out there, and get some well-seasoned, well-trained production counsel to work with you. Find, medical consultants that can work with you. Find the experienced line producers and safety coordinators. Develop a rapport with an insurance broker. Talk to your union signatory reps. Let them know that proactively you care about these things. Let them know what you're doing and pick their brain about the information that they have, which they acquire from what others are doing. And that's pretty much the focus of our talk. I hope there are folks out there that found this useful and helpful. It's just a broad overview. Next month, we'll be back with some further information. Maybe it'll still be about COVID-19. Maybe we'll go off in a different direction and talk about important things that you should know about financing your film or clearance issues, things of that nature. But take it serious. Remember, we're only making a movie here. You know, nobody should ever have to die because we're just making a movie. And I have a whole separate collection and a whole separate speech about OSHA safety in general and how inherently dangerous filmmaking is. And I'm a big supporter of guerrilla filmmaking, right? Do what you can to get what you can when you need to get it. But, you know, there's a big red light and stop sign when any of that guerrilla stuff in any way, shape, or form compromises safety on the set. You know, you don't want to be in a Midnight Rider situation where, you know, people die on a movie set because they just blatantly disregarded and went guerrilla. Couldn't get a location release from a train company. We'll just go on the tracks and have someone yell if a train is coming. Yeah, you didn't map out the physics of how fast a train is coming before people need to get off that bridge before they're killed. And the folks found culpable for that are being hauled back into court. They spent some jail time. They're on parole. They violated their parole because they're back engaging in filmmaking, and they didn't think the authorities were going to find out. They did, and they're not happy. Their rule that said you are not to ever be engaged in the profession of filmmaking again, or perhaps for some period of years, was not taken seriously by the people that had that imposed against them, and now they'll feel the full weight of the law as a result of that. So please don't let that be you. Safety's got to be everyone's business. Safety needs to be your business. I hope you enjoyed the seminar, and please come back, tell your friends, and it will be posted probably come Monday. It will be posted on YouTube, and I believe it'll be up on MovieMaker Magazine site and the Pierce Law Group site itself. So until then, thank you, and remember to tip your waitresses.